What we're talking about today is the California 919 Franchise Investment Law Third Party Sellers Act. Now, this is something that would affect any transactions that are occurring inside of the state of California. So if you're a broker in California, if you have a candidate, a franchisor in California, anything to do with California, those are kind of the parties that this would be playing a part in. So you, as a franchise broker, if you choose to do business in California, once this becomes legislation, there is a way to go through and kind of bypass the legislation, and that would be to become a real estate agent in California. They do have an exclusion that says that you can be a real estate agent in California. If you are, then this does not apply to you. However, for the rest of us who are not going to be a real estate agent in California, we need to work on preparing for this information and getting ready for it. So I have spent an enormous amount of time and effort going over this legislation with my team of advisors and legal team, and we have been pouring through all the details in the act, trying to figure out the different components inside of it, researching all the terms, because legal or law is not the same language as you and I talk. It doesn't mean the same thing with a normal conversation as it does with the legal definitions. And because of that, we needed to take the time and effort to understand what those legal definitions were. How does this all play into one another? And this might be a little scary, but I want you to know that we have made a ton of progress, a ton of really good progress in going through this. Because we've been able to break it down in the way that we have, we've prepared some very compelling points that we can provide to legislators and to the IFA. And IFA, they communicated that they have the capacity to make recommendations about changes to the law prior to it going into effect on August 28th. When the decision is made final. When I started in the association in 2008, the world of franchise brokering was a joke. It was really like there was nothing to it. There was no materials for the franchise. You had about a paragraph of information on a franchise and a commission. That's what you had at your disposal to be able to identify what brands would be good for certain people. And so brokers at that time, it was next to impossible for them to really be able to customize a solution for their candidates. So instead of figuring out what the candidate needs, they had to get just very, very good at promoting this one franchise. And so because that was the model back then, the buyers didn't really have the same level of support that they do today. Today, we have so much data, we have so much information. We are able to be discerning about what is truly right for the individuals that we are helping find these franchise matches. So all of that to say, that's kind of the foundation, but I'm going to go through some of this information and help you to understand the bill and then help you to understand the impacts of it. So California 919, it's basically a registration law. So it's a disclosure that is requiring that a third-party seller register as a third-party seller under California, and that what it's doing is it's saying that the consequences of not disclosing properly or registering properly include consequences up to rescission. So for those of you that don't know what rescission is, rescission means that the entire amount of the investment would be returned to the franchisee. So it would put them back to a whole position of where they were before they started the franchise. So this is things like the franchise, all their lease, like all of those things that they are now liable to as a franchisee. Rescission basically says we're gonna pay back all of that, and you're going to be in the position that you were before you had any of that. that. So that's what rescission means. So it is basically saying that the entire amount of the investment would be returned if the registration process is not managed appropriately. So currently the act is not for bad acts. Rescission is for non-compliance with the registration. That's one of the kind of main issues that we're going to talk about how we're going to work through, but it's also concerning because the way that it's written today, it has a lot of undefined terms. In law, you don't want legislation with a number of undefined terms because it creates opportunities for lawsuit, because it doesn't say in the law, and the only way to interpret it is through lawsuits, which then create case law, which is now how that law is managed going forward. So the way that that is structured is that it's kind of creating this opportunity for case law to define, unless we help to get definitions in this next month, in August. If we can get those definitions clearly defined, then there's less opportunity for lawsuits because people can act within the definitions and not act in things that will create exposure to them. The IFA is stating that case law would be how the definitions would be defined. We kind of countered and said, well, we would like it not to be that way. We'd like for more definitions to be in it and more clarity around the proposed act so that we can ensure that we're not creating more lawsuits, especially lawsuits to unintended parties. What we don't want is we don't want a situation where the broker doesn't understand or doesn't comply with a term, and then from there, they're now brought into a lawsuit that they really didn't have control of, they didn't have a say in. They weren't the decision maker. They didn't sign the contracts. They weren't a party to that agreement where you have two people who go into an agreement, and then when it doesn't work out, instead of them, working it out with each other, taking this person over here and saying, well, now you're responsible. The way that I kind of put it into perspective is, if I used to be somebody who loved matchmaking. So I loved finding people who were just awesome, great people who were single. And then I loved getting them connected with one another and setting up blind dates and then having them go through the dating experience. And sometimes they dated for long periods of times, and sometimes they got married. When somebody gets married, maybe before they do that, they might go to a wedding counselor. They might seek an officiant to help them write the vows that they would manage their marriage with. They might go and get some registrations and get things prepped and ready for their marriage to begin. They build a family, they build a house, then they get divorced. This is kind of saying, well, because there's all these undefined terms in the divorce settlement, the person who set them up, the officiant, the wedding counselor, if one of them paid, in this case, it's like one of let's say the husband, if the husband had any way of compensating them, then they would be drawn into this suit as well and be part of the divorce settlement. So that doesn't really make sense because these people weren't parties to the marriage. They weren't the ones that were deciding, we've dated, we want to go ahead and be married, we want to make these commitments to each other, and then they do. When you have parties that aren't decision makers, that don't hold that authority, and yet are being held responsible for the divorce settlement, that's problematic in our view, and we want to make sure that we're helping people to understand that that's what it's saying and how to work on guide the legislation in a more clear and effective way. So the Washington requirements and the New York requirements are what they're stating is kind of their model of how they did this. They're claiming that, franchising didn't end and didn't go through immense problems or challenges in those two markets, and that this is the similar. Well, from our view, they're kind of saying that it's exactly the same, except for these 10 things that make it completely different. And so let's talk about what some of those 10 things are, because that argument, if they're case and their view is that they want it to be like the Washington and New York registration process. Hallelujah. Let's do that, because the Washington and New York registration process is very simple, is very easy to comply with, does help people to understand who the bad actors are within the space. They make those things public, and that is something that we would welcome and love to comply with. That would be just fine. So here's the 10 things we want to talk to IFA about modifying in the legislation. So the first one is that the way it's written, it's kind of combining third-party sellers. So it's taking an FSO and a franchise broker, and it's merging them into kind of one group. But as we know, an FSO acts like the franchisor, and the franchise broker educates and creates referrals to the franchisor. So they're essentially different functions, and yet in the act, they are lumped together and then have the same recourse and the same consequences. Now, the FSO has contracts with their franchisor client that are different than our contracts, and no one except for the franchisor and the franchisee have a contract with each other. So we don't have a contract as a broker with our potential franchisees. And so it creates this weird situation where the referral, if you're thinking of it in like stockbrokering terms, it's kind of like the referral to the stockbroker instead of the stockbroker being regulated. And that's not typically the normal person that you would regulate. You would typically regulate the person that conducts and manages the transaction, not the person referring to the person who conducts and manages the transaction. Now, if you think about what a broker is doing, a broker is not going through and deciding for the a franchisee buyer. What they are doing is they are listening to them, collecting information about what they're wanting to do. Then from there, they're researching, finding franchise options, checking territory to see what's even available. Then they're compiling this list of the brands that they think are going to be a great option for that potential candidate. And they have to win the buyer's interest in those brands. So they provide this list of however many options for the potential franchisee. And then from there, the franchisee has to say, yes, I want to learn more, and begin the due diligence process with one of these franchises. So the broker is not selecting the franchise to which the candidate is talking to. And the act kind of misunderstands that the broker is not doing that selection. The candidate or the potential franchisee is selecting the brand. And then from there, the broker provides education and support materials throughout the process, but the broker is not able to make a decision for the franchise and is not able to make a decision for the candidate. We are not the ones in control. We are the ones that are helping support communication. We are helping support leadership thinking and strategic thinking on the behalf of the franchise candidate, potential franchisee, and even helping the franchisor and their rep to understand the candidate's position and their style. How do you talk to them? How do you work well together? So our education process is to educate and support them through. But when it comes time to making a decision, that decision is made by the franchisor and by the franchisee. The broker is not a party in that decision. And because they're not a party, we can't say no. We can't say, oh no, sorry, Mr. Franchisor, you are not allowed to offer this to the candidate. To the candidate, we are not eligible to say, candidate, you are not allowed to sign with this franchisor. We do not have that authority. And so the act should separate these two essentially opposite functions. The franchise system itself has to at some point say, yes, I want this person or not, but the broker is not doing the franchisor's sales function. So that is a really important distinction that is not made here. Next, the Act, we talked about undefined terms. The Act uses terms like indirectly involved. It uses offer or sale of a franchise. It makes the distinction between offer and sale. It says attempting to affect a sale. So attempting to affect a sale could be a lot of things. It's not defined in the Act. It also says that you can be promised a fee or have other forms of consideration. So because you're promised a fee and can be paid in other forms of consideration, which means anything of value, which is very loose and undefined and could mean a lot of things, because it has those things, and there's a lot of room for misinterpretation. If you think of it from the Washington or New York, because there's no rescission involved, it's not really worth it for a attorney to go after and say, hey, you didn't register properly, I'm going to do a lawsuit against you. Because California ties in this rescission component, what it's saying now is if a franchisee fails, and that attorney can now say, we can get the entire investment and all expenses that were already paid back. Now the claim that's available is quite significant. If a franchisee is looking for an attorney to basically take this case, you're going to invite contingency lawyers because now there's a big amount of money to go after. And so they're going to be looking for these undefined situations where they can potentially prove that someone was indirectly involved, that they were attempting to affect, that there were other forms of consideration made. And so we just need to clean these things up because we don't want to create a situation like that. There's enough in it for an attorney that is a contingency lawyer to now say, hey, this makes sense for me to spend my time on because I can prove that this lead source over here was indirectly offering a sale of a franchise. And I can say that this attorney over here was promised other forms of consideration and indirectly offered a sale of a franchise. So there's just all this vagueness that we want to be clear about before this goes into law so that we can do the work to correct it and make sure that it is nice and clean. So we're not inviting things like that into our beautiful and amazing franchise space where there's so much good in franchising, and we need to keep that sentiment and keep that experience going. Having the red line will help us to kind of put some of those things into terms and help the IFA and the legislators to know what are some other ways to handle these situations and to handle this language. The next thing is number 4 is material change. Currently, there's no definition of material change other than material change is a change in services offered, a change in compensation, and a change, I think it was like a change in litigation. The change in services offered and the change in compensation can be problematic because a material change being a change in compensation would create a large administrative burden on someone who was being very proactive to comply with this and try to keep material change off of them. So if a broker or let's say a lead vendor is wanting to keep this material change off of them, then in order to do that, because the law is undefined, you either have to have case law that now determines what a material change is, or we need to define it better in the law. So I think this is pretty easy to correct, but it's a big deal in the application because currently a material change requires an update with the state. So California says you have to update us if there is a material change and you have to pay a $50 filing fee for that addendum. This could be seen as you have changes every day. That's not a material change, not a big deal. Or if you've got these attorneys over here that are looking for problems and they say, oh, that was a material change, you didn't update your addendum, now there can be an issue. So we think that because of the consequences attached, material change needs to be very, very clearly defined, and that it does not include change in service or a change in compensation. Because as we know, we work with hundreds of franchises and commissions change all the time, every day. Services that we offer to one candidate might be slightly different than services we offer to another candidate, because they're different people and they're looking at different models and they're looking at different brands. And as such, they require different support and questions and needs. And so we want to kind of help IFA to change that language and then propose it to the legislators. Now, IFA's comment on this is that material change is defined by case law in the franchise law. But because this is not the same, this is a new law dealing with third-party sellers. And while it has some pieces that are attached to the franchise law for franchise and franchisee, the franchisor and the franchisee, it does not define third-party seller in that. And so those material definitions and case law do not apply to this new law. So their statement is a change in commission like that isn't going to be a material change. And all we're asking is, if that's not your intention to make it a material change, then let's define it. Let's go ahead and put it in the law up front so that it doesn't become a nasty lawsuit on the back end for no real reason on something that you didn't even intend. So that's what we're asking for, which seems reasonable because they're in agreement that it shouldn't be an administrative burden of $50 a day. And they're in agreement that materiality is something larger than kind of the base model here of just a compensation change. The next one being a service change. So if you change in services, we kind of talked about that, but that's something that we don't want to be listed as a material change. It can be included, like you give a general list of services, but don't make that a material change. The sixth item is that it asks for personal contact information of potential past potential buyers. So it's asking for in the last year for the people that bought, and what is their name, address, and email address. And they're asking for that to be disclosed, including the number of units that person selected. Here is where the issue is. When a franchise disclosure document is delivered to a candidate, it's related to that specific franchise that they're interested in looking at. It also contains the franchisee's business contact information. It does not include their personal contact information. And we as franchise brokers are not authorized to provide personal contact information. We do not have a contract for service. They did not pay anything to us. And so because there's no payment, agreement and payment for services, we are not authorized to give what this act is asking for. In addition to that, personal contact information is their personal information. One of the parts of the act is that it says that this must be given at the beginning of the process. So as soon as a conversation, email, any kind of exchange occurs, then the information has to be provided. So now if you think of every franchisee, now each and every franchisee who purchases a franchise from any third-party seller, not even just brokers, because a third-party seller now means anyone who is paid or compensated anything in that award process by a franchisor or franchisee, and it's got other definitions as well, but anyone who's compensated in that early process. So your lead vendors, this would be anybody who sent a referral besides a franchisee. Those parties would be considered third-party sellers. And as a third-party seller, they would have to provide this list of contact information of all the franchisees whom they indirectly engaged in and attempted to offer. Because these terms are so loose, it means that personal contact information of most franchisees are going to be distributed at the beginning of the process to anyone interested in franchises in California. And then it also says any franchisee, so it's not only restricting to California franchisees who bought, it's saying anyone in the country who bought. So now just think about this from a franchisor perspective. Your franchisee's personal contact information is being now given to pretty much every lead in the marketplace. I mean, that is pretty alarming. And do we really want to be the kind of organization or the kind of community that's blasting personal contact information to a lot of people? So this is highly problematic for everyone in franchising. We don't want the personal contact information to be provided to whoever submits a lead or goes on a website. I mean, there's just a major privacy concern, and I hope that you guys agree with me on that, because it seems inappropriate. For what benefit? The contact information is already provided for that particular franchise system in the disclosure document. So they already have access to what they're looking for. It also, because it has things, this is the next one, 7, because it says there's other forms of consideration, and because it says is promised a fee, a sale does not have to occur for a non-registration violation to have occurred. It's not tied to a transaction. If a contingency lawyer is now looking at the law and saying, okay, we've got this law and this person didn't register properly as a third-party seller, and because they didn't register properly as a third-party seller, they've now violated this act. It doesn't have to they're not connected. So I don't know what the amount would be of a lawsuit like that, but the act doesn't have a connection between the actual sale and an actual transaction and the ability to create a problem for that third-party seller. The act also doesn't take into consideration the bad acts are already covered under current franchise law. We already have law that says that if you make misrepresentations in the sales process, then you can be sued for those misrepresentations. So that's why we're so diligent about having you be FTC sales compliant. That's why we're diligent about teaching you the legal process and having legal memos and having attorneys come on and teach you about how to stay compliant with the franchise law. And it's pretty simple. Don't make misrepresentations and don't talk about item 19 information that's not directly in the item 19. That's the law. And if you do things that are outside of that and you say, oh, you're going to make so much money, that is a misrepresentation, and that is already covered under existing law. We have an act that creates a consequence that isn't attached to the act. And then the next one, 9, is that the act requests uniform third-party seller disclosure document, but it doesn't actually provide one. We do have an example of one from IFA that since IFA wrote the legislation per Sarah Davies, because they wrote it and they have this third-party seller disclosure that was provided in the NASA information and it's online for them too, we assume that those two things are adjoined or are meant to be adjoined, but it doesn't actually adjoin them. And if it does, like on the California site, they're not connected. And the uniform third-party seller is mentioned, but it's not provided in the actual act. So we don't want an act that has a form that isn't provided, and the act and the third-party sellers have different definitions. So they're not the same definitions, which creates issues. And then the third-party seller disclosure actually says that we are selling, or it says something to the effect of we're selling a franchise, or we're a third-party seller and offering a franchise. Franchise brokers are not eligible to offer a franchise for sale. So if it's saying that we have, like, it's kind of forcing a misrepresentation in that it's saying that we have to say that we are selling a franchise when we don't actually have the authority to do that. And then the act also creates a requirement. The 10th thing is that it creates a requirement to write out all forms of compensation that a franchise broker is paid. And it says, even form not only the amounts of the calculation, but also are the amounts of the compensation, but the calculations of the amounts, which is completely different than any other industry. Your attorney does not have to give you a list of everyone that's bought from them, how much they paid for their services, how those fees were calculated. A realtor does not need to give you a list of everything that was paid, the amounts of the calculation, of who those people were. It's essentially a personal financial statement, but in the form of this disclosure process. So it's very unusual in other laws, and it doesn't match basically what benefit does that do. I think what they're trying to do is they're trying to make brokers not make decisions based on the highest commissions available. And the broker isn't the one deciding for the candidate, though. So the broker doesn't get to decide for the candidate what franchise they are able to purchase. The broker or the franchisor doesn't get to decide what the broker will do. It's like we're not those decision-making parties. We're simply allowing them to see the options. We're helping to educate them and communicate and get them on their way together, but we're not actually the ones that are making those decisions. So to request this kind of financial information is above normal standards that no other industry that we can think of is defined to that other than a franchise. But a franchise is asking for a 10-year contract, additional fees that are charged per month. And for those, they're having a promise of services. And because of that, the only way for the franchisee to know if those validate is for them to actually go through this process and have all these things, have these checks, and have the ability to talk to franchisees, see this information. It's actually in some ways more extensive on the broker than it is on the franchisor, and yet the broker has no ability to impact the transaction other than to encourage communication, encourage strategy, encourage clarity in the process. So we are not going to let you guys just try to manage all of this yourself. It's too much. It's too aggressive for you guys to just say, okay, I'm an independent broker. Let me take on all of this compliance and management process and cost. That is not us. We are not that company. We're the company that stands with our people. We're the company that takes action. We're the company that does what's right. We're the company that researches, that does the work to make sure that you guys have what you need so that you can run successful businesses and help be the good in franchising.